Well, hello there, ladies and gentlemen. Great to see you again, and welcome back to Closing Arguments. I'm Ryan Ruff, your moderator, and as always, I will be joined by Jack Razumich of Razumich and Associates, where we're going to be jumping back in to a very, very pivotal case that we've been covering here on the show for quite some time now. That is, of course, the title of today's episode is Truth Stranger Than Fiction. We're diving back into the case of the state of Indiana versus Richard Allen. This is part 4 of our series covering this particular crime that has seemed to just get not just local, but of course international attention given the twists and turns. And of course, we most certainly appreciate all the feedback that we've been getting from you guys, our audience out there that has been tuning in and enjoying the conversations. We're happy to share this with you, and we've got some more stuff to sink our teeth into today. But before we get into those details, let's go ahead and say hi to the man of the hour. Jack, great to see you today. How you doing?
Hey, Ryan. It's great to be back as always. As a good preview, this will probably be our last episode on Richard Allen for a little while. Our first episode, we kind of covered the background of the murders in Delphi. The second episode, we covered the first 75% of the Franks motion. The third episode, we covered kind of what happened, what the fallout from that was. And we ended where today's episode is going to start, with the Supreme Court stepping in. The Supreme Court has made their rulings on both of the original actions that were sent before them. Not to give too many spoilers away, because, of course, time of recording, we are behind the real world on this right now. So everyone who's watching this probably knows that Baldwin and Rozzi were reinstated as attorneys on this. And the case is kind of at a standstill. So this is going to be a good stopping point for this series right now. But we'll talk about that when we get to that point. But we should be able to cover everything and bring everyone watching up to speed with how we got to where we are, I guess. Where we go from there, we'll figure that out together.
Yeah, that sounds like a coin toss at this moment, based on the twists and turns we've experienced in this case.
Yeah.
Well, Jack, why don't we, you mentioned the words original action there a moment ago. And, for those that may have just jumped on board for this podcast series, when we started covering this case in particular, one of the things that we love to do on this show is to educate the audience on your dealings in criminal law and these interesting concepts that maybe we think we know something, but we don't know the whole picture. So why don't we dive into this idea of an original action? Talk to me about what it is, how it operates. Let's set the scene on that, and then we can get into how it's really playing out within this case in particular.
Sure. An original action is basically any type of litigation that would start directly with the Supreme Court, in this case, the Supreme Court of Indiana. The way that our judicial system is structured, the supreme judicial authority for any jurisdiction, whether it's the federal jurisdiction with the Supreme Court of the United States or the 50 individual states and their state Supreme Courts, they're all organized basically the same, which is that there is a Supreme Court that oversees all judicial actions. And 99% of everything that goes before a Supreme Court is going to go up on what's referred to as appellate review. And appellate review is the process of, you have your trial court level issue. And then depending on whether or not you win or lose at the trial court level, that issue can be appealed up to the Intermediate Court of Appeals. And then based off of that, it can be appealed further to the Supreme Court.
So original actions, Jack, they're no joke. I mean, we're elevating this situation to the highest of levels, but are there any limitations when it comes to original actions, and who, the when, the how? But frankly, just are there any limitations when it comes to these original actions?
Yeah, they're very highly limited, to be perfectly honest. They're highly, highly disfavored by the courts. It's effectively, I know I used the concept of asking you to speak to the manager a few moments ago. The way that the Supreme Court treats original actions would be a little bit more akin to a military chain of command. You're probably not going to go straight to talking to a general without talking to a colonel and a captain and a bunch of other people along the way. So the very first thing that you always learn when you're looking at trying to get an original action moving is the Supreme Court's going to basically tell you, exactly why are you bypassing the normal rules of procedure? They're very disfavored because the process is supposed to be you have your trial court issue, you have a ruling from the trial court. If the trial's not done, you can ask for an interlocutory appeal that can be accepted or rejected. And then once the trial itself is done, you have your regular appeal. Uh, Original actions, very specifically, are not supposed to be a substitute for appeals. They are limited to situations where if there is not immediate relief, catastrophic outcomes happen. You normally see them on prisoner cases. So, for an example, if a prisoner has been ordered to receive a new trial because of something like DNA evidence or some sort of other post-conviction issue that led to an appellate court ordering the trial court, hey, take him back and give him a new trial. If the trial court's not transporting him, the trial court's not having that trial, that's the type of thing that you send a writ of mandamus for, because you basically are saying, Judge, I'm sitting in prison. I've been told I get a new trial. The court's not doing anything. Tell them to move me. So that type of catastrophic situation, and we will discuss a little bit what the Supreme Court's reasoning was for why they granted the writ of mandamus in this situation. But that's they're very limited in that regards. So you've got two major limitations there. The first limitation being you have to convince them that this is appropriate. You have to convince them that they should listen to you right now instead of telling you go to the back of the line and just wait your turn like everyone else.
Right.
And the second is you have to convince them that these are extraordinary circumstances requiring an extraordinary remedy. And if you can't hit those two benchmarks, then you're not getting an original action. That's basically it.
Well, I'll tell you what, I mean, you use the word extraordinary. I think that's a very applicable word to the case that, of course, we've been examining over the last few episodes, the state of Indiana versus Richard Allen. Why don't we take this as the natural segue into talking about the different original actions that have popped up in this case, the writs that came down along with them. Why don't you set the scene for us, Jack, on the very first of the original actions that came in, all surrounding that, the irregularities, if you will, with the court record?
Sure. There were, in the Richard Allen case, there were a total of 2 original actions that were filed in this case. They were filed at different times and for different purposes. The first original action dealt with arguments that the trial court was improperly maintaining the court record. In a bizarre possessory sort of way, all trial court records belong to the Supreme Court of Indiana. That again goes to the concept of, they're the supreme judicial authority, everyone answers to them, they lay down the rules. And as a result, one of those rules are you have to maintain a clear and accurate record of what happens in your case. As it relates to the Richard Allen case, there were a number of filings that were made primarily by the state, but also to an extent by the defense, that just did not show up on the chronological case summary. The chronological case summary is effectively basically a chapter index for the trial. It basically just says, on this date, this pleading was filed. On this date, this pleading was filed. On this date, this pleading was filed. It is very much just a rote chapter of contents like that, or table of contents like that. So what was weird with the Richard Allen case and what was causing problems is it seemed like the trial court was actively hiding or concealing that things had even been filed. And that represents a problem because that makes it unclear as to what actions were or were not taken. So, for example, the Franks brief that kicked all of this off, the reason that we had a copy of it, the reason that anyone had a copy of it, is because it was put on the chronological case summary for a whopping 30 or so minutes when it was first filed, and then it was just gone. It was like it never existed. And that's a problem because the rules are very specific that if it's filed, you have to note that it was filed.
Yeah.
You can prevent it from being accessible to the public at large. There are rules with that, and it's the rules that cover that are what are referred to as the access to court records rules. And there are very specific things that need to be done to satisfy withholding a pleading that's been filed. And even if it's withheld, that doesn't mean that you can just ignore that it was there. So, for example, one thing that happens in all criminal cases in Indiana, if there's a felony conviction, the court orders the preparation of what's referred to as a pre-sentence investigation report. A pre-sentence investigation report, just very briefly, it is kind of a biographical, not biological. That would be completely different. A biographical snapshot of the defendant, their criminal history, their family history, their education history, employment history. The idea is it's supposed to help the court determine what programs are going to be necessary for this person's rehabilitation, what type of a risk they show for reoffending based off of voodoo science. But a pre-sentence investigation report is considered to be a confidential document. It is only accessible to the attorneys of records in the case. So if I went to a case that I did not personally handle the trial work on, I can't access the pre-sentence investigation report. Even though I'm a court officer, I can't access it. What I can do is I can see that it was filed. And that was what the problem was that was what the problem was argued in the first original action, is that the court was improperly not even identifying that these things were filed. It's one thing to basically say, we are not allowing this to be for public access. It's another thing to basically say, oh, I don't know what you're talking about. It was never filed because you can't see it there.
Mm.
And another issue that was brought up with the original action was that it's almost like Special Judge Gull was maintaining two separate sets of records.
Mm.
Because under normal circumstances, what would happen is if you go to the chronological case summary for the individual case that you're going on, there's just one CCS there. And it's going to be in whatever courtroom the cause has been filed into, so on and so forth.
Sure.
Because Judge Gull was a special judge appointed from a completely different county, it seemed like she decided to also make all of the pleadings, or a good chunk of the pleadings, available through the Allen County website. This case, I remember, is in Carroll County, Indiana. Judge Gull had assorted pleadings on the on the Allen County website.
Mm-hmm.
Those pleadings were not in any type of chronological order. They were just kind of a big jumbled mess. And the argument for the original action was that the special judge was improperly maintaining the court records. They were not accurately reporting what was and was not filed. And they were impermissibly preventing public access to records that should be public access. So that was the main thrust of the first writ. I'm sure I'm missing some things. Kara Winicky, who is a friend of mine, handled some of the heavy lifting on both of these original actions. I'm certain that anything I miss, she is going to tell me about. So, hi, Kara. You can tell me what I screwed up later. But that's generally the thrust of
Sure.
what we were looking at with that first original action, is the argument that the court was improperly maintaining the records, and as a result, no one knew what was going on.
Right. But, and a hard but at that, the Indiana Supreme Court ended up denying the writ that came with it. So why? Why was that the case? Why was that ultimately their ruling?
They ended up denying that writ because they found that the issue was moot. Mootness is a judicial term of art. It basically means the issue that you're asking us to rule on has been resolved. So as the original action was going on, very briefly, the way that an original action proceeds is if the court grants standing to entertain the original action, the party asking for the writ files a brief. The judge or whatever other government official is being asked to do something is able to file a reply brief. The original person can file a response to that. It's very similar to the appellate process in that regard. While all these briefs were being filed, Judge Gull basically corrected seems like kind of the wrong way of phrasing it, because there are still a few things that are a little bit weird with it. But she did direct her staff to work with the Carroll County staff to fix the issues that were being complained of. There are still some irregularities. So, for example, I can see, and it is a matter of public access, that the motion for a Franks hearing and the motion to suppress was filed. The brief is still not there as being something that was filed, despite the fact that we all know it. But at least the major pleadings seem to have made it onto the court record in the correct order.
Mm-hmm.
Um,
Got it.
when the Indiana Supreme Court denied that first writ on the basis of mootness, they also gave an extended lecture to everybody regarding the rules for the access to court records administrative rules, talking about when things can be confidential, when things can't be confidential, what needs to be filed along with that. For example, when we file expungements, we have to file it's referred to as an ACR 5. That's Access to Court Records Rule 5. And it basically states, hey, we've redacted social security numbers out of this because that's one of the things you redact out of it. That's part of the Access to Court Rules issue. Personally, in my opinion, I don't think that it was a moot situation. I think that there are a lot of things, even though they're back on the record, that are not properly accessible for no discernibly good reason. So when we talked about this in the last episode, when Brad Rozzi filed his motion to disqualify Judge Gull and or his declaration of I'm staying on the case, those were originally stricken from the record, and the concept of those were pleadings that specifically Judge Gull said, you're not entering these into the CCS. Those were put back into the CCS, which is kind of one of the things that helped the court to decide that this was moot. The problem is they're not available for public access, at least not online. Part of the way that I read it, it seems a little bit like they were trying to split hairs on that. Judge Gull was arguing that you can come directly to Carroll County and access it from there. You're just upset that you can't access it from the comfort of your own home.
Mm-hmm.
That may be a gross oversimplification. Either way, there was nothing about those pleadings that, in my opinion, represented a confidential issue or something that needed to be restricted from public access. So, in my opinion, I don't think it was moot. However, it is at least gratifying to be able to have the clear table of contents again.
Sure.
We can only see what has happened, 99% of it anyway.
Yeah.
But that was an improvement. But that's what the Supreme Court decided on. That was that, well, the major issues that are complained about have been fixed, therefore it's moot. We're going to deny the writ on the basis that it's no longer necessary. So that was the first one. That was the easy one in the grand scheme of it.
Sure, it's moot, but it leaves you scratching your head a little bit at the end of it. But let's pivot now, Jack, over to that second original action we've seen come down, and that's surrounding the entire removal of Richard Allen's attorney. Talk to me about this original action and the flare up that led to this, and then of course we'll get into the writ that came down as a result.
Sure. If you recall from the last episode, one of the things that we had talked about was there was a lot of fireworks that surrounded the filing of the Franks brief. Very clearly, Judge Gull was not happy that the brief, I can't even necessarily say it was leaked to the public. It was part of a public filing, but it got out to the public. We had the situations with the unfortunate suicide, the theft of the crime scene photos, and all that culminated with Judge Gull basically giving Baldwin and Rozzi the Hobson's choice of you can either voluntarily withdraw right here, right now, or I'm going to go out and dress you down in front of the entire, assembled cameras of the world. They took the concept of, okay, we're going to withdraw because that's professionally in Richard Allen's best interest. We're not going to prejudice his case in that, humiliating of a fashion. We'll do that. when they had the time to sit and reflect on it and decided, no, this is wrong, this is not appropriate, we're staying on the case. And not only were Brad Rozzi's original attempts at disqualifying Judge Gull and his declaration of intention to stay, not only were those unceremoniously stricken from the record, when they showed up and filed pro bono appearances and said, we're going to be the attorneys here, what are you going to do about it? We're not under your authority anymore. And Judge Gull says, like, no, I've disqualified you. You're not staying on this case. That triggered the concept for the original action. The argument being that by going straight to removal, that was an extraordinary decision of last resort that was unwarranted in the totality of the circumstances. The irreparable injury or the catastrophic injury that would happen to Richard Allen is the loss of continuity with his counsel. The significant delay that would be caused by having new counsel try to get up to speed. So that was the first issue that was brought up in the second original action. They also brought up two other issues with the original action. They brought up the concept of disqualifying Judge Gull as part of that original action because, of course, Brad Rozzi had filed to disqualify Judge Gull right away, and that was not addressed. That'll be one of the things we talk about here in a few moments. And they also asked that the Indiana Supreme Court order that Richard Allen's trial start within 70 days. I think we talked about this, might have been way back at our first episode. The concept of a fast and speedy trial. There are different trial rules in Indiana that declare when your trial can happen. And if you're in jail and you want a fast and speedy trial, that's when they have to do it within 70 days. So as part of the second original action, it was a three-part argument. The first being that Baldwin and Rozzi need to be reinstated as public defenders, that Judge Gull be disqualified, and that the trial start within 70 days. So those were the issues before the Supreme Court. They took an extraordinary step on this case, which is not something that normally happens. And that's that they scheduled oral arguments on this case. Mm. That's not common. I mean, oral arguments before the Supreme Court for appellate matters, I'm pretty sure are mandatory. I don't practice appellate law, so don't quote me on that. I know I know that oral arguments are discretionary with the Court of Appeals. I am 99.9% positive an oral argument is required as part of the Supreme Court rules. Mm-hmm. But that's for appellate issues or for other original action style issues. Writ to mandamus very rarely have public import to justify requiring an oral argument. Like it's like filing a motion for continuance at the trial level. It's like, sure, the court can set an argument on that if there's like remarkably extraordinary circumstances. Generally speaking, though, the court's just going to rule on it. And that's normally what happens with writs of mandamus in these original actions is the court normally just rules on it. The fact that the Supreme Court ordered an oral argument in this case, in my opinion, as an outside observer, was kind of an indication that they were very much aware of how out of control, for lack of a better way of phrasing it, this situation got. I think that by ordering the oral argument, it was very much kind of an indication of like, okay, we're going to step in, reset this back to normal, kind of get everybody on the same page, straighten you guys out, and then send you on your merry way.
We need to talk this through.
Effectively, yeah. It's like basically, mom and dad are here to explain to the children what's going on. And that at least seems to be, in my opinion, if they took that extraordinary step, what they were trying to do with that is just basically, again, try to put on a good face for everyone else, because you're correct. This has international attention on it. Mm-hmm. And I don't know at the trial level if the Carroll County prosecutor, if Judge Gull, I'm not even 100% sure, to be perfectly honest, whether or not Baldwin and Rozzi kind of have an awareness of the amount of attention that is on this case. The Supreme Court definitely does.
Mm-hmm.
You don't get to be on the Supreme Court if you do not have a degree of political savvy. And that's not to say that being elected prosecutor or being elected judge doesn't require some degree of political savvy, but you're looking at the difference between, your big fish in your small pond versus we are responsible for the reputation of the judiciary as a whole.
Mm-hmm.
And right now, because of shenanigans happening with this case, it's presenting the Indiana judicial system in a bad light. We're going to put on a good front for this. But I think the Supreme Court is very well aware of the attention this case is getting, and maybe not the black eye, but definitely certainly kind of a smudged eye that we've gotten to this point. And I think that was another reason why they granted oral arguments in this one, or rather ordered oral arguments on this one. It wasn't requested. Like the Supreme Court basically just said, we're scheduling oral arguments on this. They were, of course, live streamed. All the local stations watched the arguments on that. But I do think that was part of the concept on that, is just basically show that, again, we know what we're doing. The adults are talking now. We're going to get this fixed.
Sure. So, well, you mentioned the oral arguments being live streamed. The question that begs to be asked, and which is really kind of our final theme that we want to jump through in today's episode, is what next? What happens next with this case? There's some, we've seen fireworks behind us. Are there fireworks to continue? In your eyes, Jack, what comes next?
Well, first, let's back up just a couple seconds and kind of go over what did happen with the Supreme Court. As I mentioned at the top of the show, they did grant this original action in part. As I said, there were three elements to it. There was the element of reinstating Baldwin and Rozzi. There was the issue of disqualifying Judge Gull. And there was the issue of starting the trial within 70 days. The court, on a 4-1 vote, decided to order the reinstatement of Baldwin and Rozzi as public defenders. The court unanimously rejected the request to disqualify Judge Gull, and they unanimously rejected the request to start the trial within 70 days. That decision came down like 4 hours after the case was argued. I mean, they moved very quickly on that.
Wow.
So they issued the initial order very quickly, and they indicated that they would, without hesitation, I can't remember the exact language. Promptly. They said promptly. They indicated they would promptly issue a formal written order describing their reasoning. Conveniently, thanks to, again, as I've mentioned on many times, this is not my day job. The delay in between filming episode 3 and episode 4, they did finally release their formal written order. I believe that happened last week on the 9th. The reasoning for the Supreme Court's decision with regards to reinstating Baldwin and Rozzi, it was very much, again, the concept of continuity of counsel and the significantly negative impact on what would happen with Richard Allen's defense. They were very concerned about the fact that prior to their removal, Baldwin and Rozzi were indicating that they would be prepared to proceed to trial within 60 to 90 days by appointing new public defenders that kicked the case out almost a full calendar year at that point in time. So there was the issue of, you have a man who, regardless of your opinion of whether or not he did it, he enjoys legally the presumption of innocence. He is considered to be an innocent man, and he's in prison, which is not where innocent people go. We've briefly touched on this, I'm sure, at some episode, but there is a difference between jail and prison. Jail is where people are awaiting trial. These are people who have not been convicted yet. They enjoy the presumption of innocence. Prison is where you go when you've been convicted. Those people are guilty. And, not only were there the multiple requests from Baldwin and Rozzi, I think we talked about this very briefly, his replacement public defenders filed to have him removed from prison because of the inhumane conditions that he was suffering in, like the psychological issues, the physical issues. There was a discussion of that very briefly on that about like, are we causing him further issues by delaying that trial for so long? So those issues overwhelmingly did lean them on the concept that reappointing the public defender, reappointing Baldwin and Rozzi as public defenders was appropriate. They also, as I mentioned, as part of the argument earlier, Judge Gull's move to disqualify them, again, that's the nuclear option. That is your extraordinary last resort issue. So you went from basically 1 to 100 in 2 seconds on that one. And that was not something the Supreme Court found to be particularly appropriate on that. It would be similar to if, the state, we have automatic discovery rules in Indiana. The state's supposed to release this evidence file to us within about 30 days of us filing our appearance. It would be like on day 31, us going to a court and telling the trial judge, Your Honor, they haven't given us the discovery. You need to dismiss this case. That's effectively how that went. You went from basically no previous issues, no previous sanctions, all the way to like the extreme sanction on that. And that was one of those things that the Supreme Court did not think was particularly appropriate.
Well, it's telling. It's telling for it's telling for
right. Yeah. With regards to the other two issues, the court's logic on denying the request to disqualify Judge Gull and the request to start the trial in 70 days are very consistent with the way that our current Supreme Court in Indiana has ruled on things. Our current Supreme Court here in Indiana is very, very procedural. It's very much, they want to see the T's crossed. They want to see the I's dotted. They want to make sure that everything goes the way that it was supposed to. With regards to disqualifying Judge Gull, that had not been heard by the trial court. So from the Supreme Court's decision, from the Supreme Court's perspective, and I can't say that they were wrong on this, that issue is not properly before them. It has not been litigated. It has not had the normal procedure. The fact that she removed them from the case, her reasoning, whether you feel like giving her the benefit of the doubt or not, at least was tentatively like on the concept of we're trying to make sure that Richard Allen has competent representation that I have confidence in. It was enough of a justification for the Supreme Court to basically say this in a vacuum is not an appropriate thing to address in an original action. Go back to the trial court, litigate the situation, send it up on interlocutory appeal if you have to, but we're not going to deal with this on a writ of mandamus. Same situation with regards to starting the trial within 70 days of the issuance of the writ. There had not previously been a written request under Indiana Trial Rule 4B indicating we want a fast and speedy trial. Because that had never been filed, it was not appropriate in the original action for the Supreme Court to basically step in and say, we're going to do the trial within 70 days. And they even put in their order that, they're free to file that now that they're reinstated. They are absolutely free to refile that. And that was basically it. And that came out about a week ago. So that's what the Supreme Court did. Mm-hmm. And now we can move on to what happens next.
Of course, which is quite the loaded question. So, Jack, I mean, there's a lot to sum up here in terms of this case. Look at how many conversations it took us. Here we are in episode 4 covering this case. This will effectively be kind of our final conversation unless something drastic comes down that shifts the balance of the case. But where do we want to leave our audience, Jack, with how things are sitting now and where this case could ultimately go?
At this moment in time, overall, time of recording, things are largely progressing the way that you would normally expect to see a case proceed. After Baldwin and Rozzi were able to refile their appearances as public defenders in this case, the alternate public defenders from Allen County dutifully withdrew their appearances, so Baldwin and Rozzi are the only two attorneys left on the case. Judge Gull denied outright the suppression issue that was being sought by Baldwin and Rozzi. She denied that without a hearing, which legally the court can do. Again, it's a little bit of an extraordinary set of circumstances. Under normal procedure, a judge will typically allow an attorney who is arguing that something that evidence the state has seized or evidence the state has collected should be suppressed. They will normally allow that to actually be a hearing, but it's not required. And in this case, Judge Gull made the determination, I'm not going to have a hearing on this. I'm just going to deny it outright. Not long after that, Baldwin and Rozzi filed a new motion to disqualify Judge Gull, arguing that she's biased. Now we'll do it the way the Supreme Court wants us to. Prosecutor Nick McLeland has filed a formal motion of contempt seeking to hold Baldwin and Rozzi in contempt of court for violating orders relating to the issues that they were originally disqualified by Judge Gull for, namely the theft of the crime scene photos, the argument being that it was negligently maintained or negligently secured. There was the issue with regards to accidentally sending an email to a non-party, which again, that seems pretty petty in my opinion. As by everyone's account, it really does seem like there was nothing sensitive or confidential. That's one of those hyper technical situations. I think there was just basically kind of just, again, a general, they're actively showboating and whatnot, so they need to be reined back in. That motion for contempt is still pending. The motion to disqualify is still pending. It's questionable as to what direction Judge Gull is going to go with any of that stuff. I mean, let's be perfectly honest. I'm going to go out on a limb and say that Judge Gull is not going to find herself to be biased and disqualify herself.
I can't imagine that would be an outcome, Jack.
I suspect that's going to happen.
Is it possible? Sure. Is it probable? No.
Sure, it's possible. I mean, you got to remember, Judge Gull's a special judge on this case. This isn't her courtroom. The old argument, not my circus, not my monkeys. I mean, theoretically, she could decide that, you know what, I don't need this grief. I got my own stuff to do, and just basically bounce out of it.
Well, also on top of that, I mean, she's got the Indiana Supreme Court that's weighed in once now and said, hey, we don't believe that those actions were appropriate. So that's going on in the back of her mind as well. So
it's possible, but yeah, let's be perfectly honest. She's not going to disqualify herself, whether or not the Court of Appeals or the Supreme Court ends up hearing the issue of the recusal at a later point in time after the procedural issues have happened. That's potentially a thing that will be a down the line situation.
Sure.
The contempt issue is a little bit more of a wild card right now, because a court has broad powers over what sanctions to impose in contempt. They can basically give a finger wagging warning to not do this again. They can order attorneys to not pursue certain types of arguments. They can disqualify certain witnesses. They can order monetary fines. And this again goes right back to the concept of you went from 0 to 100. Yeah. Theoretically, if you're found to be in contempt of court, the judge can put you in jail.
Yeah, there's a lot that can happen there.
And, are Baldwin and Rozzi at risk of being incarcerated by the judge? I'd like to say no. I mean, again, that gets to a remarkably extraordinary set of circumstances. I mean, I've been practicing for closing in on 18 years at this point in time, I think. I've seen witnesses held in contempt of court for failing to obey subpoenas. I have seen defendants held in contempt of court for swearing at a judge. I've never seen an attorney held in contempt of court for zealously doing their job. Whatever action Judge Gull decides with regards to her contempt, if she finds Baldwin and Rozzi being contempt of court, that's almost certainly going to add fuel to the fire for any appellate request to review the motion to disqualify.
Mhm.
Um, but that's a long ways off.
Sure,
I mean,
sure.
Baldwin and Rozzi at this point in time have been back on the case for almost a month at this point in time. Where we stand right now, as I said, the only major issues that have happened are that the Franks motion was ruled on without the need for a hearing. They refiled to disqualify. The prosecutor filed for the contempt, and the judge has basically kicked the contempt hearing down the road. But there will be a formal hearing on it. But yeah, that
Yeah,
brings you up to speed on where things are. From
sure.
here, the issue is going to come down to one of whether or not Baldwin and Rozzi file a formal request for a fast and speedy trial. I will concede I was in court all day before we recorded, so I've not seen the chronological case summary. I don't know if that has actually been filed. It very well could have been. That means that the trial may happen within the next 70 or so days. If it does, we'll probably have at least a brief blurb update on that. But
Of course.
I'll be perfectly honest. I suspect that if Judge Gull does not disqualify herself, which again, she's not going to, there will probably be some procedural efforts to get that reviewed by the Court of Appeals. And that'll delay that trial process again. So
Sure.
we're basically at a good stop point on this one. This is literally about as up to date as I can get this for everybody.
Sure.
There's not gonna be a lot more coming up soon that I'll be able to fill a full hour with. So
Of course.
it's kind
Well,
of where we stop.
sure. So to our audience, we are going to be returning to kind of our regular scheduled programming, if you will, as we move on from this episode. But as Jack just mentioned, should anything change, new developments come down for this case, we'll evaluate and certainly circle back, because we know you guys out there are a hungry audience, always interested in new developments with regard to this case and some great discussion. So we'll obviously be keeping an eye on it moving forward, and be ready when the time comes to be able to provide you with that update. But Jack, really appreciate you, carving some time out of your busy day. I know after a long day in court, it's tiresome to jump into a whole new case. But appreciate your time today, and I look forward to being back on the next one with you.
Absolutely. We actually only have 2 episodes left in this season. I think that for the behind the scenes stuff, Ryan and I usually chart these things out. We had this originally for 2 episodes, and then it went 4. So I think that the next episode we're going to do is going to be. I think that we had it set aside for True Attorney Confessions. For those who have come along because of the Richard Allen case, I do hope you stick around. Go listen to some of our older stuff. It's all really good. Listen to the Hot Dog Man case. Ryan and I really enjoyed doing that.
That's a fun one. That's a fun one. A lot of good stuff out there. But yeah, looking forward to being back, with you, Jack, and of course, for all our audience out there, we appreciate you all stopping by and spending time with us here on the show again today. If you did enjoy today's discussion, you learned a thing or two, or you're interested in sticking around for future content, make sure you subscribe to the show on whichever platform you check this out on today, so that you don't miss out on those future episodes where Jack and I dive into case studies. We dive into interesting criminal proceedings, the do's and don'ts, maybe some FAQs, a lot of great information that we bring to you guys on the show, and we'd hate to have you miss out on any of it. Before Jack, I'm Ryan. We're going to go ahead and say so long today. But once again, we appreciate you stopping by and being with us on Closing Arguments.